Hello, good afternoon. Before heading to discussion of passing of Charter of 1726, we must discuss the reasons which necessitated the passing of Regulating Act of 1726. Today's topic of discussion is different types of courts and position of judicial administration before 1726. So let's discuss. So there were different courts, types of courts were created in these three presidency towns, that is Bombay, Madras and Calcutta, by the company suiting to the local conditions. In Madras, four courts, namely the Court of Governor in Council, number 2, Court of Admiralty. Number 3, Mayor's Court. Mayor's Court was established by Charter of 1687 and number 4 was Choilty Court were in existence. Whereas in Bombay there were various courts, namely Central Court consisting of Governor and Council. Second, Admiralty Court, and number 3 was Court of Conscience. The Court of Conscience was for civil actions and number 4 was Panchayat. So these courts were in existence in Bombay. Similarly, in Calcutta, there were the courts of Governor and Council and number 2, Collector's Court. So this system of courts was existing at three presidency towns before 1726. As there was no uniform procedure of law and lack of training in law, the presiding officers of these courts functioned in the most arbitrary way and they used to decide cases according to their whims and fancies of the individual judges, because basically they were traders and they were not lawyers, and therefore they used to decide cases according to their whims and fancies. The entire judicial system was in doldrum. Judicial administration at Calcutta. So position of judicial administration before 1726, judicial system at Calcutta and Bombay differed greatly, and state of administration of justice was at its lowest ebb, or it was decline, म्हणजे उतरती कळा, because in Calcutta zamindari rights were granted to company and thereby they used to discharge the function as zamindars also. But in Bombay, the judicial administration was different and therefore the judicial system at Calcutta and Bombay differed greatly and state of administration of justice was at its lowest ebb. Maintenance of law and order even amongst Englishmen who were employed by the company at these presidency towns became a serious problem. Decisions of the Indian courts were not recognized by the court in England, and its consequences was that in many cases English people were again tried in England for causes which arose in India and settled by the Indian courts. The directors of the company realized the growing discontent, that is dissatisfaction and weakness of the company's state of affairs, and therefore efforts were made to find out some suitable means which will tackle this problem. As the court which had been established in India by the company by virtue of powers vested in it from time to time. With the growth of commerce and trade, the company realized the necessity of suitable machinery for administering justice in these three presidency towns of India, which should be respected and recognized by the courts in England. The company was interested in avoiding litigation against itself and amongst Englishmen in England in various matters concerning probate administration, legal claimant, testamentary, and in state jurisdiction, etc. And therefore, the company was very anxious in protecting the legitimate interest of its own servants as well as the interest of those Englishmen who had settled down in India in the company's territories and died in India, leaving behind considerable property without any legal heir to inherit it. So, on the whole, it may be concluded that after long experience, the company realized the necessity of properly constituted courts in all these three presidency towns. So, by the year 1726, the company was deeply rooted in the Indian soil. So, with this, I have completed the different types of code before passing of Charter of 1726 in the three presidency towns and the position of judicial administration before 1726. Thank you.